So first of all, good afternoon, and thank you to all of you for joining us for this discussion, comparing two very different ways of arbitrating disputes in England and Wales on the one hand, and in the US on the other. For those of you who don't know me, my name is Julie Tripp. I'm Global Claims Counsel at Liberty Specialty Markets, and I'm also co-head of education at ARIAS UK. Joining me today are Joe Gebara, Senior Vice President and Chief Claims Counsel at SCOR, and Paul Baker, a partner at DAC Beachcroft, specializing in political risk, trade credit, terrorism, and political violence insurance, and also international arbitration. Both these gentlemen have extensive experience of arbitrations on both sides of the Atlantic, which is why they've very kindly agreed to come and speak to us today on the key features and differences between how each of these two legal systems approach this form of dispute resolution. Please note that we are recording this webinar, and we do plan to post it on the ARIAS UK website for a short while afterwards. So those of you those people who were interested in attending today but weren't able to can have the opportunity to view it afterwards. Paul and Joe have also advised me that they are happy to take questions as and when they arise, so no need to wait until the end. But if you could please just use the raise hand function, that would be appreciated. Also, do feel free to put questions in the chat, and I will do my best to get to them during the webinar. Paul, if you could put that table of contents slide up.
I think it should be up according to my screen.
Is it? Okay. Yeah. So, yes, it is. So as you can see from this table of contents, we've got quite a few areas to cover. But as we have only an hour, thoughts on each topic from each jurisdiction are likely to be quite summary in nature. But that way we will hopefully keep to time, but still cover plenty of ground. So let's dive in. So first up, we have governing law. And let's start with you, Paul. What is the statutory regime governing English law arbitrations?
Thanks, Julie. In this jurisdiction, as is shown on the screen, we're looking at the Arbitration Act 1996 primarily, which came into force on the 31st of January 1997. It applies to all arbitrations, domestic or international, commenced on or after that date that have their seat in England, Wales, or Northern Ireland. Now, a little bit of history on this. The Arbitration Act 1996 contains many provisions and concepts based on the UNCITRAL model law. And for those not in the arbitration lingo, as it were, that's a framework law that assists states in reforming or modernising their laws and arbitral procedure. And the model law wasn't incorporated wholesale for a number of reasons in this jurisdiction. But some of those included the fact that it was not perceived that the model law was comprehensive. For example, there's no provision in the model law on appeals and a point of law, which is something we'll come back to later. It contains some provisions that were considered undesirable in this jurisdiction, such as the requirement for obligatory pleadings. And again, that's something we'll come back to a bit later. But also it was felt the model law failed to state the principles that underlie arbitration and arbitration law. And for example, the Arbitration Act 1996 sets out those principles expressly. And importantly, in the context of a lot of what we're going to talk about today, Section 1B of the Arbitration Act states that the parties should be free to agree how their disputes are resolved, subject only to safeguards as are necessary and in the public interest. And the principle of party autonomy is clear from the structure of the Arbitration Act, but it's also interestingly, given that we're doing this with ARIAS, it's stated on page 1 of the ARIAS rules, together with the principle that the object of arbitration is to obtain a fair resolution of a dispute by an impartial tribunal, and importantly, a provision that's often forgotten, without unnecessary delay or expense. So the choice available to parties and party autonomy is demonstrated most clearly through mandatory and non-mandatory provisions within the Arbitration Act. As one might suspect, mandatory provisions are those considered necessary and in the public interest and cannot be waived by agreement, either in a bespoke arbitration agreement or via the incorporation of institutional rules. And we're going to point out some mandatory and non-mandatory revisions as we go through this presentation. But one can say that importantly, within the confines of the Arbitration Act, where you have a non-mandatory provision, that provision very often says at the beginning, unless the parties decide otherwise. So that's kind of where you're looking when you're looking at English-seated arbitrations.
Great. And Joe, what's the regime that you generally follow in the United States?
Yeah, thank you, Julie. So the U.S. Federal Arbitration Act is a much less comprehensive legislation than I think the UK 96 Act. And it goes back 100 years. It was originally enacted in 1925. There has always been a bit of judicial hostility in many courts to arbitration agreements. And the Congress back in 1925 originally passed this act to require the enforcement of arbitration clauses. So the basic act in the U.S. is governed by the U.S. Federal Arbitration Act. We'll come on to a lot of the terms of that in a few minutes. But it's important to also note that there are a number of state law provisions that relate to arbitration. Some of them are supportive of arbitration. Many of them are hostile to arbitration. And so you have a bit of a patchwork between federal and state laws on how arbitration applies, whether it's enforceable, and so on. And so we'll come on to how that works in just a moment, but it's important to keep in mind that there is a dual system of regulation on arbitration in the U.S. between the federal laws and various state laws. Julie.
I think you're on mute, Julie.
Sorry. So thanks, Joe. So moving on to the enforceability of arbitration agreements. Now, of course, normally one would expect that if there's an arbitration clause in a contract, that's how the parties are required to handle their disputes. But of course, Joe, you've just mentioned about certain states being hostile to arbitration. So what is the general view of arbitration, enforceability of arbitration agreements in the US?
So the enforceability of arbitration in the U.S. is a bit of a mind-bending exercise. And so bear with me as I try and explain it. But in the U.S. system of law, we have both the federal law and various state laws. Now, ordinarily, when there's a conflict between those laws, a federal law will take precedence over state laws. And Section 2 of the Federal Arbitration Act states a very strong federal policy of enforcing arbitration agreements. And so that's the main provision that says arbitration agreements are enforceable, notwithstanding any state laws to the contrary. Now, there's an exception to that, and that's an exception for insurance contracts. And that exception is under some legislation called the McCarran-Ferguson Act. And this was an act that was passed by the Congress shortly after World War II, because there's been a long tradition of the regulation of the business of insurance being regulated by the states and not by the federal government. And the McCarran-Ferguson Act reserves to the states the authority to regulate insurance. And there's a carve-out from the Federal Arbitration Act to say that if there is a state law that invalidates arbitration of insurance contracts, that state law will actually take precedence over the federal law. So we have what's called reverse preemption of arbitration agreements in insurance contracts. But then we have something called the New York Convention. The New York Convention is an international treaty originally enacted, I believe, in 1958 and was codified in U.S. law in 1970. And that provides that the signatory nations' courts are obligated to enforce arbitration agreements. And that's been interpreted in a very recent decision, which is an important decision by the Second Circuit Court of Appeals about 2 months ago. The Second Circuit is an important court in the US because it's the Federal Court of Appeals that governs New York. And of course, there's a financial center that becomes a very influential court. The court in the Second Circuit, joining a number of other federal courts of appeals, have held that if a party is a foreign entity that is foreign to the US, that an arbitration clause in that foreign, an arbitration clause in an insurance contract with a foreign party is enforceable, notwithstanding the state law that reverse preempts the Federal Arbitration Act. So the bottom line of all of this is arbitration agreements, if you are a domestic US insurance company, will be governed by the law of a particular state. But if you are a Lloyd's syndicate or you're a European insurance company and you have an insurance or reinsurance contract in the US, the arbitration clause in that contract will be enforceable.
Good to know. Paul, is it similarly complicated in England, or is it a bit more straightforward?
It's a bit more straightforward. Thank goodness. I was getting worried before Joe finished that final element. It's far more straightforward in England and Wales. This jurisdiction is seen as a very pro-arbitration jurisdiction. It's safe to say that courts tend to bend over backwards to enforce agreements to arbitrate, especially where, especially in things like insurance, one might find a patchwork of jurisdictional provisions in a single contract, and the courts will try their darndest to give effect to arbitration. Broadly speaking, in this jurisdiction, the agreement needs to be evidenced in writing, agreement by both parties. And in that regard, the courts push the sanctity of contract and requiring the parties to uphold the bargain they agreed to in terms of referring their disputes to arbitration. If you go to Section 5 of the Arbitration Act 1996, it's right there in black and white, that the provisions only apply where the agreement is in writing, and any other agreement between the parties as to a matter is effective for the purpose of the Act only if in writing. Now, one thing to think about there is it is not necessarily the case that if you have a particular court set out in your policy, you could never go to arbitration. Far from it. If you determine the seizing of a particular court under that contract that you would rather go to arbitration, as long as your contractual counterparty agrees, you can still go to arbitration. You just have to set out your agreement in writing as per Section 5 or particular institutional rules. There are a couple of other points I just wanted to make about enforceability in this jurisdiction. One is the principle of separability, and that's set out in Section 7 of the Arbitration Act, which is effectively, and I won't quote it ad nauseum, but effectively, if you have an agreement that contains an arbitration provision, that provision will survive the invalidity or the alleged invalidity of the remainder of the contract. And that makes sense. Because especially if you're in insurance and you have an argument as to a breach of the duty of utmost good faith, etc., or fair presentation, technically that policy doesn't exist as one of the arguments, but you can still arbitrate that dispute, and that's really important. And I've also put anti-suits on there. Those are not limited to this jurisdiction, but ultimately the court is very happy to issue certainly domestic anti-suits where a party seeks to seize the English court as opposed to going through arbitration as it had previously agreed, but also international anti-suits, effectively another party to the insurance contract seeking to seize its local court, for example. While the English courts can't compel those courts to do anything, those anti-suits, if given by the English courts, are a pretty powerful tool to change the behaviour of parties who have gone to a forum other than that which was previously agreed.
Okay. Now we're going to move on quickly to confidentiality. So in the insurance industry, we always talk about arbitrations as being private and confidential, so that if we're involved in one, we can't discuss it and discuss the outcome at large with others in the market. But is that always actually the case in England and Wales, Paul?
Well, I'm gonna ask people to bear with me now, because confidentiality in England and Wales is not actually as straightforward as one might seem. It's a common misconception for English-seated arbitration that it is confidential as a matter of statute. It's not. The Arbitration Act does not state that all arbitration is to be confidential, and that was deliberate by the drafters back in 1996, as they decided the task of setting out the scope of the obligations and, importantly, the exceptions to it was both difficult and controversial. So they preferred to have it dealt with on a case-by-case basis as a matter of common law as developed by the courts. And recently, when we've had the Law Commission looking at amendments that have now found their way into statute here with the Arbitration Act 2005, again, there was a push for a 2025. There was again a push for a provision of confidentiality to be included, and again, they decided against that. So the position stays as a matter of common law, and there's a degree to which that's somewhat controversial. At present, until the Supreme Court determines otherwise, there's a Court of Appeal case called Ali Shipping versus Shipyard Trogor, which determined that parties to the arbitration, as well as the tribunal, are under an implied duty to maintain confidentiality of the hearing, documents generated and disclosed during that process, as well as the award. But importantly, that implied obligation of confidentiality can be amended by agreement. And this can be done by a separate agreement, a separate provision within your arbitration clause. You say this will be confidential, that's obviously expressed, but also via the incorporation of particular rules. So if you look, and again, appreciating we are here for ARIAS, if one looks at the LCAA rules, terrible set of rules, ARIAS far better. There are detailed provisions imposing obligations of confidentiality within that, subject to exceptions that broadly mirror the position under English law. And there's also express provision of for the parties to obtain an undertaking of confidentiality from all of those involved in the arbitration as well. Similarly, if one looks at Article 22.3 of the ICC rules, the tribunal there is entitled to make orders concerning the confidentiality of the arbitration proceedings or other matters connected to the arbitration, and also take measures regarding trade secrets. I use those as two examples because when one looks at the ARIAS rules, the provision, which I haven't referenced in my notes actually, but the arbitrators have the power to require suitable undertakings from the parties that the proceedings will remain confidential. So seemingly within the ARIAS rules, it proceeds on the basis of the implied term of confidentiality pursuant to the case that I mentioned a moment ago, as opposed to an express term such as the LCA rules.
Okay. So in the US, Joe, is it bound by a statutory regime or is it contractual?
Thank you, Julie. Similarly, there is actually no statutory basis for confidentiality of arbitration in the US. It's really a matter of contract terms. It is, I think, generally the practice that parties believe that the process is to be confidential. But even when the parties agree on that, the courts don't necessarily accept that. So this usually will arise if a party is seeking to either confirm or set aside an award and wants to file proceedings, or if there's proceedings about the appointment of an arbitrator and so forth. There is a very strong public policy by U.S. courts about freedom of speech, freedom of the press, freedom of access to the courts. And so you have to make a motion asking the courts to seal a record so that it's not publicly available. And courts are often reluctant to do that unless there's some truly proprietary information that would otherwise be disclosed. And generally, the burden is on the party seeking confidentiality to prove the need for that confidentiality. So I'll just leave it at that.
Okay, thanks, Joe. So far we've talked about effectively the framework of the arbitration. But what about those individuals who will serve as the arbitrators deciding the dispute? So Joe, looking at the rules in the US, are there any particular qualifications that you need in order to be an arbitrator?
Well, I think this is the most actually important, probably, distinction between US arbitration practice and in the UK. And it's also probably the most important factor in determining the outcome of an arbitration, which is determining who the decision makers are going to be. And the distinction in US practice from that in the UK and other jurisdictions is the expectation that party appointed arbitrators are not necessarily or even usually neutral. They are usually appointed by parties after discussion, interview, and the determination that the party appointed arbitrator is likely to be supportive of the party's position. And then those two party appointed arbitrators will select the umpire. And if they don't agree, there's a process for that, which we'll come on to in a moment. Now, that's not only a general practice, but it's actually been accepted by the courts. And this another Second Circuit decision I've cited there, another Underwriters at Lloyd's case. If you're looking for any U.S. law that explains this, this is a good case. But basically, most insurance contracts will have a requirement that all the arbitrators must be disinterested. But the courts have said disinterested doesn't necessarily mean neutral. Disinterested essentially means that the party appointed arbitrator doesn't have a financial interest in one of the parties, and or doesn't have a close family relationship with one of the parties. The fact that a party appointed arbitrator has done work for parties in the past is not disqualifying. And again, there's an expectation that they will actually act as de facto advocates for the party that appointed them. Now, the umpire, that's a different situation. The umpire is expected to be neutral. And but again, the standard of disinterestedness is I think quite more limited than it might be in England and Wales.
Mm-hmm. And moving to England and Wales, Paul, I suspect your answer is going to be rather different.
Ooh, do people get animated about this subject in this jurisdiction? Yes, it is quite different. And I've got something to say about qualifications, but we'll say it in the context of the next particular topic. But neutrality is a key component of English seated arbitration, and it's not just the lack of actual bias. It's certainly recently there has been a focus on a lack of perceived potential bias. And I say it's had a significant amount of attention. The case on the screen is possibly not the starting point for it, but it had a huge amount of attention in this jurisdiction. It went all the way up to the Supreme Court. And I know someone on the call was involved in that, so I'm certainly at risk now of misquoting it and being shouted at. But if people can give me the time, I think it's worth just walking through that case, the principles that came out of it, and where we now are as a matter of statute, possibly not as a direct result, but certainly heavily influenced by what happened in that case. So in that case, the English Supreme Court, like the lower courts before it, was required to determine whether the chairman of a Bermuda form arbitration was to be removed from his position upon Halliburton's application because of appointments in two other arbitrations. Now, all three arbitrations in this instance concerned issues arising out of insurance claims in respect to the Deepwater Horizon disaster, and the arbitrator in question had been appointed as chairperson in the Halliburton Chubb arbitration, but had subsequently accepted appointments in two other arbitrations. Now, one of those other arbitrations did involve Chubb specifically, but both of those other arbitrations involved the legal representatives of Chubb, and the arbitrator didn't disclose those subsequent appointments. And Halliburton sought their removal on the basis that circumstances existed that gave rise to justifiable doubts as to their impartiality. And critical to Halliburton's position were that his acceptance of the appointments made by the same law firm in the second and third arbitrations, which I've just talked about, and the chairperson's failure to notify Halliburton or give it the opportunity to object. Now, the High Court and the Court of Appeal dismissed Halliburton's application. And while the Supreme Court set out a helpful analysis of the issues, it similarly dismissed the application, albeit on different grounds. They're actually quite specific to the way in which they analysed the issues. But some of the points, not all of the points, but some of the points in summary that the Supreme Court said were the obligation of impartiality is a core principle of arbitration law, and in English law, the duty of impartiality applies equally regardless of how the arbitrator was appointed. So whether that's by the parties, by the arbitrators who were already appointed, by an arbitral institution, or even by the court. And secondly, an objective assessment must be undertaken of whether, and this is the important element, whether the fair-minded and informed observer would consider a real possibility of bias to exist. Such an observer would have regard to both the realities of international arbitration as a form of dispute resolution as distinct from court-based litigation, but also the custom and practice of the relevant field of arbitration. Now, following Halliburton and Chubb, but before we got to the Arbitration Act 2025, the English court did actually demonstrate its commitment to apparent bias being a really quite serious issue within this jurisdiction, and served to remove a very well-known arbitrator in another case on the basis of incomplete disclosures of prior appointments by clients represented by the same well-known London law firm. And you'll note that I'm not naming names here in any of these cases, but you can find them if you really desire to. And the Law Commission, as a result of this sort of direction of travel, recommended a statutory duty of disclosure be in part to ensure the impartiality of arbitrators be incorporated into the amended Arbitration Act 1996. And we now have that. That's section 23A, which is titled Impartiality Duty of Disclosure. And what 23A says is an individual who has been approached by a person in connection with the individual's possible appointment as arbitrator must, as soon as reasonably practical, disclose to the person any relevant circumstances of which the individual is or becomes aware. And if we look back to Halliburton and Chubb, the becomes is really relevant there. And the arbitrator must, as soon as reasonably practicable, disclose to the parties to the arbitral proceedings any relevant circumstances of which the arbitrator is or becomes aware. And importantly, and this is the last thing I'll say on this, the Act, as amended, sets out what relevant circumstances are for that test. And it says relevant circumstances in relation to an individual are circumstances that might reasonably give rise to justifiable doubts as to the individual's impartiality in relation to the proceedings or potential proceedings concerned. And the individual is to be treated as being aware of those circumstances of which the individual ought to be reasonably aware. So we are now in a space statutory in this jurisdiction where not only we are focused heavily on the perceived independence of arbitrators, but we are now in a space where there is certainly a focus on disclosure by the prospective arbitrator. I don't think there's going to be many sort of outs from now on, given that 23A is a mandatory provision, and rightly so.
Great. So now that we've discussed a little about who can be an arbitrator, why don't we have a look at one of those, about how one goes about selecting one. So what sorts of things would you consider from an English perspective, Paul? bearing in mind all the things that you were just talking about?
Yes. Not going back to the same arbitrator time and time again, as perhaps may have been the practice across the spectrum of arbitration, not just insurance, but across it in the past. There's definitely a push for expanding the pool of arbitrators in English seated arbitration and insurance arbitration as well. But the reality is, one starts with the arbitration clause. And you are bound by that arbitration clause effectively unless you agree to expand it with your other party. So if your agreement calls for the selection of barristers at the English bar of at least 10 years call with experience of insurance, that's where you need to look. But if your core, Joe was talking about this earlier about disinterested and etc. If your clause calls for retired underwriters of the class of insurance under the subject matter of the policy, so political risk or property, etc. While you might want a barrister because the issues are actually unbelievably complicated as a matter of legal analysis, if you select one, you're going to be in trouble down the line and spend a lot of money on jurisdictional challenges all the way through. So, but as I said earlier, insurance policies, when it comes to arbitration clauses, are often not perfect. I'm sure the vast majority, if not everyone on this call, will have experience of looking 3 years down the line at an arbitration clause and insurance policy and going, what does this mean? And this can be a symptom of parties agreeing that arbitration is what you want to put in your policy, but leaving the detail of the arbitration clause until the last minute, or porting an arbitration clause from a different policy because that works. But in reality, it doesn't work in the context in which you're looking here. So even if you have a clause that is unclear, one would hope that normally in the class of insurance, I'm sure everyone works in here, you would have some form of criteria that enables you to select your arbitrator. But if you don't, and you've sensibly incorporated the ARIAS rules, 6.3, rule 6.3 comes to your aid, because that says if there is no agreement as to the qualification of arbitrators or the umpire, they shall be persons, including those who have retired, with not less than 10 years experience of insurance or reinsurance within the industry, or as lawyers or other professional advisors serving the industry. And that's pretty sensible in the context of qualifications for an insurance dispute. And when it comes to the process of selecting arbitrators and who chooses who, etc., Rule 6 also helps you in the ARIAS rules. But in the event that you don't incorporate the ARIAS rules or any other rules, and you don't have a selection criteria, which in my experience is relatively rare, you go back to the Arbitration Act, and there are provisions in there that would aid you in the context of selecting arbitrators, and it sort of starts at party autonomy and goes down and down and down until the point that you actually get to the court assisting the process. I'd love to go through that process, but I'm sure it would bore everyone to tears. But suffice to say, where a party is not complying with their obligations under the arbitration clause, if you're seated in England and Wales, there are mechanisms that, unless you agree otherwise through rules or through another part of your arbitration agreement, for parties to effectively default select arbitrators. So there is quite a degree of protection in this jurisdiction to make sure the arbitration gets started.
Great. And so, Joe, bearing in mind the sort of, I guess, different approach to the role that arbitrators have in the US, what sorts of things would you be looking at?
Well, let me, if I could, make first a quick comment on experience in the UK. Many reinsurance contracts require that the qualifications of the arbitrators be someone with experience as an officer or director of an insurance or reinsurance company. Many of the senior retired judges or senior barristers in the English bar at one time or another were directors of the Bar Mutual, which is the mutual professional indemnity insurance for barristers in England, and in that capacity qualify as industry arbitrators. So I think that's an interesting observation. With respect to the U.S., again, it usually is a question of contract in terms of who qualifies. The party-appointed arbitrators, as I say, are always appointed after discussion and interview with parties. So the real question comes down to who is going to be the neutral umpire. And there are various methods if the parties don't agree. And because you can interview and discuss the matter with your party-appointed arbitrator, they rarely agree, although it has happened. So usually there's an alternative selection process if they don't agree. For example, it could say defer to the ARIAS rules. I've seen other contracts that say the president of the Chamber of Commerce of a particular European city will make the selection. That's usually a very poor method of selecting an arbitrator. It will sometimes say if you come down to two nominees that you flip a coin. And I've had a number of arbitrations where the umpire is determined by a coin flip. Incidentally, we don't sit and flip a coin. Usually the way we do that is to say that we'll take the second digit to the right of the closing figure on the Dow Jones Industrial Average as reported in the Wall Street Journal on a particular date. And if it's an odd number, that's a heads. And if it's an even number, that's a tails. And whatever the figure turns out to be on that date, that's the coin flip. A more recent approach to selecting an umpire, which I actually think is a very useful approach, is a ranking process where both sides will nominate a slate of candidates, maybe 5 or 6 candidates. Each side can strike a fixed number of the other side's candidates, and then all the parties rank them in order of who they would prefer, say 1 to 10, and the candidate that collectively has the lowest number becomes the umpire. Now, what I like about that system is it reflects a cooperative process or a collaborative process that gets to a figure so that the person who is selected understands they were selected as a result of a process agreed by both sides, rather than just having been one side's nominee or the other, which I think is a good process. Now, ultimately, if the contract doesn't provide for any method of selection, the Arbitration Act under Section 5 allows you to go petition the court and ask a court to appoint an arbitrator. Usually not a good approach. The courts tend to appoint people who aren't necessarily experts in insurance and reinsurance. So that's usually to be avoided if possible.
Got a question in the chat, actually, for you, Joe. So sort of anecdotally from what you've heard, how frequently do you think parties actually go to court for appointments?
Well, I've done it on a few occasions on cases that I've been involved in, but I would say it's relatively infrequent. I think most of the time there's a process, or the parties just agree among themselves on the process. Mm-hmm. So, for example, this ranking system that I just described is often not set out in arbitration agreements, but many parties recognize that it can be a good way of doing it. And so they just agree among themselves to allow the process to pick the umpire in that way. So I'd say it's relatively infrequent.
Okay. So we've considered the arbitration framework and selected our arbitrators. Now, let's take a quick look at perhaps the most time-consuming aspect of the arbitration process and litigation as well, to be fair, and that's the exchange of documents and information. Now, of course, this is called disclosure in England and discovery in the US. So already there's a signal that there's a pretty different approach between the two systems. So where would I look first, Joe, if I was involved in an arbitration in the US to sort of understand how I'm meant to carry out this process?
Well, again, there's no statutory formula for how discovery is conducted in arbitrations. And so ordinarily at the outset, once an arbitration panel is selected, there'll be an organization meeting where the arbitrators meet with the parties and their lawyers, and they'll work out the process that's going to be followed in terms of a case management schedule and what type of discovery is going to be allowed. I would say that the biggest difference between US and English arbitration, just like the civil litigation process, is the deposition. Whereas parties in the US have a right to take depositions of their party opponents and other witnesses. The Arbitration Act does, by statute, give arbitrators the power of a subpoena to compel the production of documents and the production of a witness for testimony. But that's primarily going to be an issue set out either in the ARIAS rules or whatever other organization rules, or if the rules don't apply, then the parties will. It's largely at the discretion of the arbitrators. Oh, could I just add one thing? Depositions in the U.S., if for those of you who have been through the process, are often contentious, and that extends oftentimes even to issues over simple things like where is the deposition going to take place. There's a fun case. It's actually a published judicial order where the lawyers could not agree on where the deposition was going to take place. They each wanted it in their own offices, and they actually petitioned the court to appoint the location for the deposition. This is in the Middle District of Florida. The judge wasn't particularly excited about having to take up his time with an issue like that, so he issued a judicial order. Each lawyer was to appear on the courthouse steps at 9 o'clock on the following Friday. Each could be accompanied by one paralegal as a witness, whereupon they were to engage in one game of rock, paper, scissors, and the outcome of that game would be the lawyer who got to choose the location for the deposition. It's actually a published order. If anyone's interested in it, I'll send it to you. Just let me know.
Oh, yes, please. That's fantastic.
More orders like that, please.
Exactly. Because I don't think we'd find that here in England, would we, Paul?
No, but that doesn't necessarily mean that we are a brighter and happier jurisdiction for arbitration as a result of that. No. I think sometimes, and I'll come on to a couple of points of this, arbitrators who bang their heads together of intransigent lawyers running arbitration through methods such as what Joe's just talked about, it can cut through a lot of noise, a lot of cost, a lot of pages and pages of letters. What was wrong with the order that Joe just said? If you can't decide, paper, rock, scissors, I'm not really too bothered. There are important issues, and then there are important issues, and sometimes those satellite ones that are less important take more time and more cost.
Yeah. So
I just see there's a question in the chat to me. Let me just quickly answer that. It says the neutrality of the umpire in the U.S. has been a concern with many parties settling cases after the coin flip. In my opinion, is that a real concern, and how's it being addressed? I think it is a real concern, and I think one of the ways it's being addressed is this alternative of a ranking process, because I think many parties realize that if you lose the coin flip, the umpire who is supposed to be neutral is basically the nominee of the other side. So that's the way I see that being addressed, is a movement toward trying to use this ranking process as much as possible.
So back to disclosure now instead of discovery. What rules am I supposed to follow if I'm in an English arbitration?
Well, I'm in raging agreement with Joe here that it's not necessarily to be found in statute exactly how one addresses disclosure in international arbitration in this jurisdiction. The closest we come is Section 34 of the Arbitration Act, which is really the go-to for procedure that effectively says the tribunal has very broad discretion in terms of a number of issues, and including at 34(2)(d), whether any, and if so, which documents or classes of documents should be disclosed between and produced by the parties and at what stage. So that's as wide as one can find. And that broad discretion is mirrored in many rules, such as ARIAS, which actually comes pretty close to repeating that. But how does it work in practice? I don't think this is necessarily a practice that is exclusive to English seated arbitrations, but one finds now that one can default to something that is a common or normal route, but one needs to remember that it's not the only route. So if we take what's on the screen there, so the IBA rules and the taking of evidence in international arbitration, broadly speaking, that's a request and response approach through the combination of those rules, particularly Articles 3 and 9 of those rules, together with a document called a Redfern schedule, which is named after the renowned arbitration practitioner Alan Redfern. And in summary, this process enables a request by a party for disclosure of either specific documents or a narrow and specific category of documents reasonably believed to exist and believed to be in the possession, custody, and control of the other party, and not in the possession of the requesting party. And importantly, those documents are required to be relevant to the case and material to its outcome. Now, as ever with any sort of process, the initial focuses on being, reducing burdens on parties and speeding up the arbitral process in this instance starts well-meaning and can sometimes then be utilised to the benefit of others. And so while it was intended to be quick and narrow, unless controlled by a very active tribunal, and one hopes that all tribunals are active, and all three normally are, what you can risk in this process is it becomes a quasi additional pleading stage. And, these Redfern schedules, they're supposed to be A4, and smart tribunals will specify their A4 as opposed to yours truly, who tends to get away with A3 unless someone says otherwise. But they end up running to like 100, 120 pages because you have columns and people are just pleading their way through it. And one of the issues with that is because one of the means by which you object or can object to disclosure of a document in Article 9 is on the basis of a lack of relevance and materiality to the outcome of the arbitration. So if you have those parameters, it is an opportunity to say, well, you don't need those documents because your case is rubbish and it's not going to be material to the outcome, and you just repeat all your pleadings. So when I say it's not the only route that can be adopted, I've certainly had experience in the past where, going back to old money standard disclosure is appropriate in the right case and shouldn't be dismissed. One can put that to the tribunal on the basis of, for the right case, a party might not know the specific, narrow and specific category of documents that might exist or might not be able to articulate. And but for a disclosure process, we're not going to get to a fair outcome of the process. So because of this broad discretion in England and Wales, one can be creative when one looks at disclosure. You shouldn't automatically default to Redfern schedules and the IBA rules. But that said, it shouldn't be for the parties to sit there and think that standard disclosure, for example, is going to be ordered in all arbitrations.
Oh, wait, I've got a question. What is the impact of the standard for applying the privilege on the production of documents in the UK?
Yeah, well, if one is looking at the IBA rules, for example, privilege is one of the justifications to not disclose particular documents. I wouldn't want to speak for the US, especially with Joe on the call, but the approach to the disclosure or identification of privileged documents in the UK court system is quite different to that in the US, in my experience. But there are a number of ways things can be dealt with. One is to simply say, well, those documents are privileged and therefore we are not going to provide them. There can be an argument as to privilege that often goes to a decision of the tribunal. And when you go all the way through the potential processes, one can see, and I've got experience of this, of tribunals looking at allegedly privileged documents in something called in camera, where the other party doesn't get to see it, and the tribunal can therefore rule as to whether or not those documents are in fact privileged or sections of them are. but it is quite contentious. That is, in most cases, quite an important satellite issue if it comes up, but it is one that yields quite a lot of argument.
I am conscious of time, so I think we might need to canter through the next couple of bits, but I think we can, hopefully. Now, because the reason why we exchange all these documents is to either support or undermine the parties' cases. But how do you know what that party's case is? Is there generally a formal document or a pleading that sets it out, Paul?
Yeah, I'll start there. And we want to counter through. So pleadings as opposed to submissions are quite common in England and Wales seated arbitration. To a degree, that's a hangover of the court-based system we have here, where one has pleadings right at the beginning of a dispute to set out one's case. And if you look at the LCIA rules, for example, Rule 15 provides for a specific written stage of the arbitration, where at 28-day intervals, you will have a statement of case, a statement of defence and counterclaim, statement of reply and defence to counterclaim, and a statement of defence. Now, that is within the LCIA rules. The ARIAS rules, for example, do not provide for that. They actually provide for the tribunal having a broad power to order whatever submissions or pleadings one desires. So again, it's not a one-size-fits-all in England and Wales, but pleadings are certainly more common in this jurisdiction than I understand they are in the US, though Joe may well correct me.
Yes. Why don't you do that, Joe?
Well, just in the interest of time, I'll say in the U.S. we don't usually have formal pleadings in an arbitration. There's each side usually exchanges a short and plain statement of the issue and their contention with respect to the issues in dispute. And I would say the main difference in the conduct of the hearing is reliance totally on live witnesses to give testimony as well as documents, as opposed to a witness statement, which is usually the process, I understand it, in the UK, and then subject to cross-examination.
Yeah.
I'll leave it at that in the interest of time.
Yes, and I think I was going to talk about how you get that evidence into the hearing, but I think you two have pretty much sort of summed that up, which is, it's still kind of broadly the way it's done in litigation in the two jurisdictions. In England, we have witness statements. In the US, we have depositions, and then the way the live testimony is done is quite similar to the way you would expect it in a court proceeding in each of those two countries. So once we've got through the whole arbitration, how do we find out who won? I mean, what's the typical process in terms of how the arbitrators effectively announce their decision? Paul, why don't you take that one first?
Yeah, just to counter through this again, you receive an award, often quite significantly after your hearing, and one of the reasons for it being significantly after a hearing is they can be quite detailed and quite lengthy. My views on why that is the case are twofold, really. The first is both institutional rules and the default position under the Arbitration Act is that awards are required to state reasons unless the parties dispose with that, for example, in the context of an award by consent. But the other aspect is something that I've put on there called due process paranoia. And this is effectively the argument that parties to arbitration often put forward with raising new arguments or making applications regardless of the time. They will sit there and assert that if this evidence or this application is not accepted, the tribunal will be in breach of its mandatory duty to treat the parties fairly and give them an opportunity to present their case and deal with the case of the other party. And if this argument isn't put in, they reserve their rights to challenge the award eventually under the Arbitration Act. And tribunals can occasionally be reticent to both turn down those applications or to dismiss elements quickly in written awards as a result of that. But I think hopefully we're moving into a better place nowadays in terms of length and detail of awards.
Mm-hmm. And how would you expect to get the decision in the US, Joe?
Well, in the last arbitration I had with English arbitrators, the decision came down. It was 132 pages long. In comparison, the last decision I got on an arbitration award in the United States was 2 pages long.
Oh gosh.
So you get a very cryptic outcome. I'd just like to say a couple of quick in the interest of time. One thing that's very important to keep in mind is whether the contract has what's called the honorable engagement clause. And in many European contracts, it might be the amiable compositor clause, which basically tells the arbitrators, particularly in reinsurance contracts, that they are not necessarily bound strictly by the applicable law, but they can apply the custom and practice of the insurance or reinsurance industry to fashion what they think is a fair outcome. So that's always a factor to be kept in mind if the contract contains that kind of wording. And I'd like to say one quick word about something that's called baseball arbitration in the U.S. This is a process, and I won't go into the detail of why it's called baseball arbitration, but if you're interested, let me know later and I can fill you in separately. The baseball arbitration is a process where a single arbitrator is selected and both sides submit their best offer and their last and best offer, and the arbitrator has to select one or the other. There can't be any compromise, and so this is a process which is designed to bring the parties closer together rather than polarized positions, because many arbitration awards often are compromise numbers, and the baseball arbitration approach is to get away from compromises, bring the parties as close together as they can, and then ask someone to choose between them, which is sometimes now I'm seeing incorporated into commercial arbitration awards as well.
Cool. Thank you for explaining that, because I've had that mentioned in some arbitrations I've been involved in, and I'm like, no idea what that is, and they just sort of move on and usually pick another way of doing it, but it's often floated. So now that we've got our various awards, someone's probably not going to be happy with the result, and they might even feel that the tribunal just got it wrong. So in a piece of litigation, when we're in court, party obviously has a right to appeal a decision, obviously subject to certain parameters. But is there anything that they can do about it if they're in a U.S. arbitration, Joe?
Very little. Every party that loses thinks the arbitrators got it wrong. What's important to know is getting it wrong, even if they did, is not going to be grounds probably for setting aside an arbitration award. Mm-hmm. That's, I think, one of the important differences between the U.S. and I understand the English practice, where there's perhaps a greater right to appeal questions of law to the courts. But traditionally, in American arbitration, courts accepted what was called the manifest disregard of the law standard, which is if the law is clear and clearly applies to a set of facts as found in the arbitration, but they choose to disregard that law and apply a different outcome, that could be grounds for an appeal. The most recent decision on this point is a U.S. Supreme Court decision that goes back to 2010. And the grounds that are set forth in the Federal Arbitration Act require you to show corruption, fraud, evident partiality, or misconduct, or that the arbitrators so imperfectly executed their powers that a final mutual and definite award was not made. It's an open question whether that standard is reflected by this manifest disregard of the law standard. In the 2010 decision, the Supreme Court said, well, we're going to assume without deciding that that's the test. And then they went on to say, but if assuming it is in that particular case, they said it applied. But it's been 15 years, and to this day, we still don't know whether manifest disregard of the law is the grounds for setting aside an arbitration award. Most courts of appeals have said it is. Some have said otherwise. But I think the important thing for purposes here is even if that is the standard, it's a very, very deferential standard toward the arbitrators. it gives them a lot of discretion and room to decide the case, and parties have very little room to appeal a decision.
I've just got a question about that manifest disregard rule. Joe, do you have any thoughts on how the fact that the arbitrators are frequently relieved from following strict rules of law, how does that factor into that sort of evaluation?
Yeah, that's a good question. I've often thought of that myself. I haven't been aware of any cases that have actually addressed that question, but I think where you do have a contract that expressly tells the arbitrators that they have a lot of discretion in how to decide the case, it's going to be that much harder to establish that it was a manifest disregard of the law.
Yeah. And Paul, what would we do in England if somebody wasn't very happy with the result?
If someone, and Ian's just put a crucial point on there, also reflecting on Joe's point about, we do, as a matter of Section 69 of the Arbitration Act, have the ability to appeal on a point of law. But not only is that a really very high bar to get over, because it's not something the English courts like to do, but we do have, as Ian's pointed out, it's a question of English law. But also, as Ian's pointed out, this is a non-mandatory provision of the Arbitration Act 1996. So if you agree either within your arbitration clause that the award will be final and no appeal may be made, or you've incorporated rules that incorporate a waiver, such as Article 26.8 of the LCIA rules that say the parties waive irrevocably their right to any form of appeal, review, or recourse to any state court or any other legal authority, insofar as such waiver shall not be permitted under applicable law. So the reality is that while one might have an appeal on a point of law, you've got a very high bar, and you may have waived it in any event. So it's not practically always available. But your other areas one can go to are not necessarily appeals, they're challenges. We touched upon them earlier. You have Section 67, which is a challenge based on the tribunal lacking jurisdiction, and Section 68, which gets people very excited, which is serious irregularity, which has or will cause substantial injustice to the applicant. And within Section 68, you're looking at things such as the failure of the tribunal to comply with its duty under Section 33, which we talked about before, and a reason why so many awards are so lengthy necessarily, a failure by the tribunal to deal with all the issues put before it, uncertainty, ambiguity as to the effect of the award, which I'm sure plenty of lawyers reading awards think is definitely there, even if they aren't, and the award being obtained by fraud or award, or by or the way in which it was procured being contrary to public policy. And I note that one at the end just to potentially leave people on this additional reading, such as the order that Joe was referring to. We've recently had a long judgment in this jurisdiction, just under 600 paragraphs, called Nigerian P.I.N.D. That is a very good read. That is a very, very substantial award that's been set aside in this jurisdiction and not enforced on the basis of you can't make it up levels of fraud and nefarious behaviour that is set out like a really great page-turner novel by the judge. So if anyone has a time and inclination, I would recommend that, not only as an example of where Section 68 works, because the vast majority of applications on Section 68 and 67 do not work or do not get through, but it's just a good read about arbitral procedure and nefarious stuff going on. But back to you, Julie.
Excellent. Well, I think that concludes pretty much what we all wanted to cover. I don't know if either of you had any closing remarks you wanted to make, or if you just wanted to move straight on to questions, if anyone has any left.
I'm happy to take any questions.
Yeah.
So we can open up the floor. I don't know if I can see hands without scrolling through. And of course, if anybody thinks of anything later, I'm sure you can reach out to either Joe or Paul or indeed myself, and we can filter things back to you. But if that is it from everyone, then it just leaves me to say thank you to Paul and Joe for taking the time out to talk us through the sort of differences and features of English and US arbitrations, and to wish the rest of you a good afternoon. And thank you very much.
Thanks, Julie.
Thanks very much.
Thank you, everybody.